Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today, we're going to discuss a significant IRS ruling that could impact how you plan your estate. This is especially important for those of you considering or who are already using irrevocable trusts because the IRS just closed a big tax loophole on us. And I think some people are going to be surprised after their loved one passes away and they get the tax bill after selling the house. Hit the like button, subscribe, share the video with someone before they try to lock everything up in trust, and let's dive in. In early 2023, the IRS quietly issued a landmark decision, Revenue Ruling 2023-2. This ruling centers on irrevocable trusts and their role in estate planning. An irrevocable trust, for those unfamiliar, is a type of trust where the terms cannot be modified, amended, or terminated without jumping through an insane amount of hoops. In recent years, more families have been using these trusts to shield their assets from being depleted in order to qualify for government benefits like SSI, Medicaid, or, for us here in California, Medi-Cal. Before this ruling, there was arguably some uncertainty about whether assets in such trusts would get a step-up in basis. By which I mean it wasn't explicit families would get the step-up in basis they were looking for, but they were getting it by implication. Before getting into the details, let's briefly explain step-up in basis. It's a tax term that means when you inherit an asset, its value for tax purposes is stepped up to its value at the time of inheritance. This could potentially eliminate capital gains taxes overall. I've got a handy infographic to illustrate this process appearing on screen now, and you can see more examples by clicking the link in the description to the written version of this video on our website. Now let's discuss the ruling itself. Revenue Ruling 2023-2 specifically addresses the situation where an individual who establishes an irrevocable trust retains certain powers, making them the owner for income tax purposes. However, the trust's assets are not included in their gross estate for estate tax purposes. An example of this could be maybe I put my house in an irrevocable trust so it's not in my name, but I retain a right to occupy it or collect the rental income from a renter. However, when I die, the house goes somewhere else and it's not part of my normal estate, meaning not subject to my creditors or my personal estate tax exposure. If you saw my recent video on how to protect your IRA and other retirement accounts from creditors, then you're familiar with the basic concept here. The IRS's decision here is crucial. It states that the assets in such a trust do not get a step-up in basis when the owner dies. This means if the trust's assets have grown in value, the beneficiaries might face significant capital gains taxes when those assets are ultimately sold. By now, you may be wondering, why does this matter? Well, as Americans live longer, more families rely on long-term care, often turning to Medicaid or VA aid and attendance for assistance. However, these programs often require you to first spend down your assets. An irrevocable trust has been a tool to protect assets from this spend down. But with this new ruling, the tax implications for beneficiaries have, of course, changed. So now what does this mean for you? If you're considering an irrevocable trust or already have one, it's crucial to understand these changes. Your estate plan might need an update to ensure it aligns with your goals and the new tax landscape. By that I mean, it's going to take some new planning and calculations to make sure the plan is still what's best for you and your family in light of this rule change, which in reality wasn't really a change in the rules, but a change in the interpretation of already existing rules. Some of you might be thinking, or really panicking, that this means there's now less of a tax savings or advantage to your existing revocable living trust because, as you should be aware, your revocable living trust becomes irrevocable at your death or incapacity. Does this mean we've lost the step-up in basis on all inherited property through a trust? No. This new rule interpretation is for property that is held in a trust that was irrevocable at establishment and prior to my death. Creating an irrevocable trust and putting assets into it effectively separates that asset from your estate, which is why, according to the IRS, we no longer receive the step-up in basis at our death, because it didn't pass through our estate to the beneficiaries at our death. By contrast, your revocable living trust is still you, it's still your stuff to manage, benefit, and enjoy. It's part of your estate that passes to your beneficiaries when you die. The fact that the trust may become irrevocable as a result of your death or incapacity doesn't remove the assets held therein from your estate. Thus, if you have a revocable living trust, then this ruling is not going to impact you or your heirs. But let me know, do you or does a loved one have an irrevocable trust that might be impacted by this new ruling? Do you just get grumpy when having to deal with the IRS? Or do you have any other questions or video topics? Let me know in the comments below. I'm Attorney Andrew Bethel. Like, subscribe, share the video with a friend or family member like your great aunt Emily. I'll see you next time.